Mr. Nifong. And I would contend to you, Investigator Hyman will tell you, as he said under oath, or I would contend what he said under oath in deposition, that when he talked to Mr. Nifong and they asked about Miss Mangum, he said she sounded like she was telling the truth. During this period of time as well, initially there were the three individuals who came forth and made the statements, and a number of other individuals were supposed to meet with Investigator Hyman and Sergeant Gottlieb. During that period of time, they got in touch with lawyers, and those lawyers advised them, probably as I would do, not to make any statements. There's nothing wrong with that. And there's certainly nothing that you could ever use in the courtroom. However, what we're talking about is the mindset of Mr. Nifong in terms of what is going on. He's looking at this case, and he's trying to make a determination about if these people initially came forward and now everyone is being quiet, why is that? And then he starts making the statements that he does. But when he starts making those statements that he's making, and I believe you will hear him testify that he regrets making those statements, but in those statements that he made, he was not making them with the intent to substantially prejudice the jury. At that point, there had been nobody charged. They were still looking for suspects. And he felt, as the duly elected, or as the DA of Durham County, he needed to solve this crime. He wanted to get out there to the public how serious this crime, that he believed a rape had occurred, that there are three people out there who, at least three people out there who were involved, and he wanted to solve this crime. And his statements were a way of getting out there saying, people need to come in and tell me, because we need to know, we need to put a bed to that. That being said, and again, some of the statements clearly were outlandish, we're talking about a very brief period of time. We're not talking about someone who talked from March until January 2007 when he got out of the case. I would contend 98% of the statements you're going to have before you were made between March 8th and April 4th. And then he stopped talking. He realized, again, I'll let him testify, but I believe he realized, A, it would be improper to go on, and secondly, too, at this point they were starting to narrow down who the people were, and he was not going to make comments once an individual was charged. And I contend almost all statements are made prior to anybody being charged, and they're not being made in reference to any one individual at the time they're being made. You've heard some comment in opening statement about the photo array that was shown to Miss Mangum and whether it was suggestive or not, or the improper nature of it. Rather than hear our conclusions or our arguments about the suggestiveness or lack thereof of the photo array, you'll have the opportunity to see that. Mr. Nifong, because this was a relatively new procedure, and he will liken it to the yearbook identification when he knows somebody was wearing a certain high school sweatshirt, and he'll show a yearbook to the individual who's making the accusations from people who were at that high school to see if they can help identify him. He knew this was a new photo array, was not positive as to how it would play in court. See, he taped it. He taped it, so we don't have to worry about whether there was some sort of suggestive nature of it. You'll be able to see it. You'll be able to make your own determination, not listening to either side about how you should interpret it. You can make your own determination as to about how suggestive it was and the purpose of it. We would contend the purpose of it was not to sort of circumvent the typical photographic lineup, but to try and locate witnesses in terms of people police could try and talk to make a determination as to what happened that night, and perhaps solve the crime that they were very thoroughly investigating. You heard at that point she did make several photo IDs. You heard Ms. Sheen comment about Mr. Hyman expressing grave concern about indicting Reed Seligman. What I will contend you'll hear, and again this is just opening statement, but you will hear Mr. Hyman stating to Mr. Nifong about, I'm not so sure whether we should indict Mr. Seligman because we can't prove he was there at the party. I would contend that was the reason why he was expressing those concerns, at which point Mr. Nifong said to Investigator Hyman, if you believe her on Finnerty, then you have to believe her on Seligman. Whereas if you believe what she says on Mr. Finnerty, then you have to believe her on Seligman, at which point the investigators went forward. Mr. Nifong did not generate a warrant on his own. He had the investigators go in to present their case to a grand jury. There'll be no evidence of any kind that they were instructed how to present the case to the grand jury, whether just to include this evidence and not this evidence, but present the case to the grand jury and let a grand jury make a determination as to probable cause whether these crimes occurred. After a presentation, and I don't believe the State Bar is going to have any evidence at all to say it was Investigator Hyman was doing anything improper or was instructed to do anything improper. After a proper presentation before the grand jury, they returned the indictments of probable cause. The grand jury determined there was probable cause to go forward as to Mr. Seligman and Mr. Finnerty at that time, and subsequently, after Mr. Nifong received DNA, the DNA report and information from Dr. Meehan saying that there was DNA on the fingernail that was consistent with Mr. Evans' DNA, which corroborated what Mr. Nifong believed to be Miss Mangum's statement that she had scratched one of the players and that she had DNA under her fingernail. Then he went ahead and indicted Mr. Evans. Again, did not generate a warrant on his own, but presented it before the grand jury for probable cause. The jury came back with probable cause. So I would contend there is no evidence at all to say anything that was presented to the grand jury was improper or not presented to them properly. And you've heard nothing about that either in the amended complaint or in the opening statement. As to the DNA, Dr. Meehan, which I would contend, if you look at the sort of contested issues, is sort of the real crux of this case, sort of the what did Mr. Nifong know and when did he know it? There's not a whole lot of contention about what went on in those meetings on April 10th, April 21st, and May 12th. In fact, I think you'll hear from Investigator Hyman, and if Sergeant Gottlieb testifies, and Dr. Meehan and Mike Nifong, pretty much the same. That there was DNA there was no DNA consistent from the rape test kit consistent with any of the Duke lacrosse players. The only DNA at all they found at any time was under the fingernail that was found in the bathroom that was consistent with Dave Evans. Mr. Nifong had never used Dr. Meehan before, and the reason he was going to Dr. Meehan was, again, that Dr. Meehan could do a certain sort of DNA testing, YSTR, I believe it's called, where you're just looking for DNA for males. And that's why you use this. And it is a very sensitive testing, much more sensitive than what the SBI can use, because a lot of times they can draw DNA from a cell or less. They meet with Dr. Meehan. Dr. Meehan gives them the information about the various aspects of what he has found. But what does not occur, and what you will not hear from one witness in this room, is that Mr. Nifong ever asked Dr. Meehan to exclude anything from that report. He said so on December 15th, and I contend he has said so under oath in his deposition, and I contend he will testify that today. He was never asked to exclude. Mr. Nifong never told Dr. Meehan how to write his report. Dr. Meehan, when he was giving the results to Mr. Nifong on his own said, I have privacy concerns. I have read quite a bit about this in the paper, and I'm concerned. I know that as soon as the SBI test results came out, everything about the SBI results were in the paper, and I'm concerned that anything I may put in this report, again, will be out there. I've got the DNA profiles of 46 players, and I don't feel it would be appropriate to place that out there. And he expressed his concerns on a number of occasions, and at some point Mr. Nifong said, well, I know that, but at a minimum, I at least need the matches.